Is Professor Susan Gillis. I am a ruthless moderator, so people should sit or leave. Okay, our panelists today are all extremely qualified, so I won't read any of their qualifications. On the far end, we have Rachel Dissel, who's going to give us the reporter's perspective. Next, we have Joseph Nye, who's going to give us the perspective for the juvenile. Next is Judge Beth Gill, who's going to give us the judges, the judicial perspective. And finally, Kevin Shook, who's going to give us the media's perspective. First, we're going to make sure that you understand key terms and key concepts about the juvenile justice system. So I'm going to ask Joe to explain to us what's different about a juvenile court. Is that yours or is that his?
That's fine. So I can switch it really quick.
Okay. It should be right at the bottom.
All right, one of the things that I wanted to go through is kind of what it says, but key terms and concepts in juvenile justice reporting is the difference in terminology that occur in adult courts and juvenile courts. There's a misconception that the juvenile court and the adult court or the common pleas court are the same. And they're different courts. They have their own rules. They have their own terminology. And although there are similarities between the two in regards to the terminology, we have a specific language that we use in juvenile courts. And so I want to go through some of those terms. I'm going to start with some real easy definitions. First of all, an adult is obviously a person who's 18 years or older, and a child is a person who is 18 years of age or is under 18 years of age. Now there's some specifics to that. I'm not going to bore you with all the details of it, but there are also individuals in our court system, for example, those who have been deemed to be an unruly child, and we'll talk about what that is in a second, that are actually considered a child until they're 21 years of age. Also a person that commits a federal or state offense before they turn 18 years of age but are prosecuted after that time are still considered a child under the revised code. The two biggest categories of juveniles that are involved in the system in regards to criminal matters is a delinquent child, which is a child who has committed an offense that would be a crime if it was committed by an adult, and an unruly child, which is one that commits an act that would not be an offense if committed by an adult. And I gave you the three main offenses for unruly child: curfew, school truancy, and unruly. They're also called status offenses. Obviously, as adults, we don't have curfews. We can't be charged with anything related to those. So those are the two specific categories that we deal with. I don't know why I just did that, but I'm going backwards, sorry. This is the biggest thing I guess you could take away from this section is, one of the things Kevin's going to tell you is that adult hearings and juvenile hearings are closely resembling each other. And there are parts that's true about and there are parts that it's different about. Here are some key terms that are used a lot. For example, pled not guilty in adult court would be entering a denial in juvenile court. We don't have guilty pleas or innocent pleas. We have pled guilty as entering an admission. Found guilty, you're adjudicated a delinquent child. A sentence in juvenile court is called a disposition. Jail is called detention. A defendant is called an alleged delinquent or the minor child. And then for the Ohio Department of Rehabilitation and Corrections, adults are sent to prison, youth are sent to a correctional facility through the Ohio Department of Youth Services. This is just an example from a recent article in the Dispatch showing teens pled guilty to role in murder. That's not something you can do in juvenile court, and we're going to talk about why that language is oftentimes used in the media for the public to understand, but a juvenile doesn't have the ability to plead guilty in juvenile court. The last two things that I have in here are two specific juvenile-related categories of offenses that come up most in media coverage because they're more serious offenses and there's a lot of questions about them. The first is a serious youthful offender, and so because this is a statewide seminar, it's an important thing to talk about. Throughout the state, serious youthful offender sentencing dispositions are not used the same everywhere. For example, in Franklin County, we've had less than a handful of serious youthful offender cases, and in Cuyahoga County, it's something they use regularly. And we're going to talk about why that's done differently in a second when we talk about bindovers or transfers. But a serious youthful offender, I give you all the language that's in the revised code about this. An act charged against a child be offense if committed by an adult. During the commission of the act, the child used, displayed, brandished, or indicated they had a firearm. So you don't really have to have one, just say that you did. Or you were previously admitted to the Department of Youth Services for aggravated murder, or a felony of the first degree, or an act that would have been a felony of the third degree, and it's offensive violence. So we'll talk about offensive violence later. But it's a lot to take in. So what is it in plain English? Plain English. A serious youthful offender is a disposition. Again, we don't use the phrase, but it's the sentence that you can get in juvenile court. That's called a blended sentence. What you get is the traditional juvenile disposition and then a state adult sentence. So the court can enforce the adult sentence later if the juvenile commits certain acts or if the disposition has been unsuccessful in juvenile court to rehabilitate the child. So basically what it does is it allows you to have a juvenile sentence and hang over the juvenile's head an adult sentence that can come in later on. And this is a key takeaway from this also, is that if a juvenile is tried as a serious youthful offender, they are entitled to a jury trial. I said we'd talk about that later. That's one of the key reasons that not every county does that, because then you're offering juveniles jury trials in your court. A lot of courts aren't equipped for it and don't want to deal with it. What's more common, and especially more common in the central Ohio area, is a bind over or transfer. So currently in Ohio law, any child 14 or older can be transferred or bound over to adult court if they're charged with an act that would be a felony if committed by an adult. There are two types of bindovers. The first is mandatory bindovers. So if a child is charged with a Category 1 offense, and I promise in a second I have a chart of what the offenses are, the juvenile court must transfer the child to adult court if the child is 16 or 17, or if they're 14 and 15, and they have been either previously committed to the Department of Youth Services for a Category 1 or 2 offense, and then we'll tie that in one more second here. But if there's a child that's 16 or 17 years old that's charged with a Category 2 offense, they must be bound over if they have been previously adjudicated of committing a felony offense and they're committed to the Department of Youth Services. The bottom, mandatory bind-over cases, the juvenile court must transfer the child to the adult criminal court if there's probable cause to believe that the child committed the act charged. In comparison, discretionary bind-overs. So in case a child age 14 years or older has been charged with an offense that would be a felony if committed by an adult, the court has a discretion to transfer them. Okay, so in discretionary transfer cases, the court may transfer them if they find first that there's probable cause to believe they've committed an offense, and then the child is not amenable to care or rehabilitation within the juvenile system, and the safety of the community requires them to be subject to adult sanctions. So quick summary of those two. Mandatory if the court finds that there's probable cause to have committed an offense for a 16 and 17-year-old in the Category 1, or a 14 and 15-year-old, they must transfer. For discretionary, and I'll show you those categories again in one second, but for the discretionary, there's a two-part process. If they find probable cause that they probably did it, they then have to find out whether they're amenable, whether they can receive treatment in the juvenile court that require them to stay in juvenile court, or whether it's necessary for them to be bound over and tried as an adult. The last things that are important to note from this, if a child is transferred to adult court, the child's treated as though he or she were an adult at the time the offense was committed. They can't come back after they've been transferred unless there's a whole process we're not going to deal with, which is a bind back. But once you have been bound over and tried as an adult, you cannot come back to juvenile court unless there are certain circumstances. But if there was a conviction in the adult court, you cannot be retried in juvenile court. Here are the two categories of offenses I referenced. This is just for you to look at later. Category 1 offenses are the most serious ones: aggravated murder, and attempted aggravated murder or murder. Category 2 is voluntary manslaughter, rape, aggravated arson, aggravated robbery, aggravated burglary, and first-degree felony involuntary manslaughter.
Thank you. I'm going to ask our reporter, Ms. Zissel, what one thing would you tell people is different about the process in juvenile cases?
Well, that's probably obvious to most people. You know, we're dealing with children here, and so I think that everybody, reporters are included, are cognizant that the process is different and that different considerations need to be spoken about with our editors in our newsroom and with the lawyers in the case in terms of how we're going to cover it. we do recognize that there's a reason that there's a juvenile court and that it's different than another court. And we've really tried hard over the years to take that into consideration and trying to figure out which cases to fight for access to and which cases to cover the best we can, without full access to.
Judge Gill, what would you say the one difference in juvenile proceedings is you want the audience to know?
Well, I think that what the audience should really know is that as a juvenile judge, I focus at all times with the concept, as Rachel indicated, that the juvenile court was created on the idea and the belief that juveniles are inherently different from adults in their decision making and or their lack of good decision making and their maturity level, and with the concept that most juveniles can be rehabilitated before their 21st birthday. And that's always in the back of our minds as it relates to any decisions that we make, including whether or not to grant access open court.
Any questions about juvenile court proceeding before we switch and say when should reporters get in? Okay, you did such a good job. They're completely educated. I'm going to now ask Kevin to take the lead and just explaining to us when, under the law, you're entitled to get access to juvenile proceedings or to get juvenile records. Kevin, take it away.
Thanks, Professor Gillis. My name is Kevin Shook. I'm an attorney with Frost Brown Todd. Over the last year, I had the opportunity to represent the media in a couple of cases that were interesting enough to require me to revise my bio. And the first case was representing CNN and trying to get access to the court proceedings for the shooting at Chardon High School. And then the second case involved access to records in the court proceedings. Represented CNN and the New York Times, the Associated Press, ABC, CBS, a bunch of other news organizations, and trying to get access to the Steubenville football player rape proceedings. And through that, we decided that this is a subject that seems to be coming up a lot, and let's do a panel discussion on it. And so I thought it makes sense to go over some of the law that we encountered in both of those cases and that we'll continue to encounter as we go forward as media lawyers trying to get access to proceedings and records. First subject is access to juvenile court proceedings. And any discussion of access to court proceedings should start with the Ohio Constitution that says all courts should be open. And the Ohio Rules of Superintendents provide that the judge shall permit broadcasting or recording, taking of photographs in court proceedings that are open to the public as provided by Ohio law. And of course, all adult criminal proceedings are open. And the reason that is the courts have decided that crimes are public wrongs affecting all members of the society, and society is essentially a party to criminal proceedings. And juvenile proceedings are a little bit different. Juvenile proceedings, it's been found that by the Ohio Supreme Court, do bear a close resemblance to criminal proceedings, which are generally open to the public. But there are specific rules in juvenile court and under the Ohio Revised Code that make distinctions. And Joe just talked about the serious youthful offender definition. I remember the first case I handled trying to get access to juvenile courts. There was a young miscreant in Athens County that had been alleged to have committed all kinds of misdemeanors, and it had made it up to Jimmy Kimmel show and had all kinds of media attention. And I thought, well, this kid was a serious youthful offender, but as Joe pointed out, this is a specific definition. And just because a juvenile is involved in a serious case doesn't mean that it's open to the public. Most proceedings I've handled fall under the second category of Juvenile Rule 27. All other proceedings, the court may exclude general public from any hearing, but may not exclude either of the following: persons with a direct interest in the case, or persons who demonstrate after a hearing that they have a countervailing right to be present. In Ohio, there's no presumption whether juvenile courts are open or closed. Although, as a media lawyer, there's lots of great law for arguing that they should be open. in this Dispatch versus Elias case that found a juvenile courtroom may be closed to the general public only in a rare occasion after determination that no other way can justice be served. So while there's no presumption that they're open or closed, that's a pretty strong statement. And in fact, starting with In Re TR, which TR involved baby Tessa, and it was a interesting custody battle between two parents who were divorced, neither were the biological parent, and a mother, the actual biological surrogate mother, all seeking custody of TR. All through Dispatch v. Loudon, there's developed this three-part test. So whenever you are a member of the media, or if you're someone seeking to close proceedings, this is what a judge will look at. First, a juvenile court can bar the press or public from, can't bar the press or public from a hearing absent a finding that there is a reasonable and substantial basis for believing that the public access could harm the child. So is there a reasonable basis that this access could harm the child, or a reasonable substantial basis that it could endanger the fairness of the juvenile proceedings? And the potential that harm outweighs the benefits of public access. So there's a balancing test. And then the final part is, and there are no reasonable alternatives for closure. And so as a media lawyer, you come in, you argue the benefits of public access to these proceedings, and if necessary, you think about alternatives to closing the proceedings. The burden of proof, there's good case law for media lawyers that it's the party seeking the closure of the juvenile proceedings that bears the burden of establishing those three factors. So as a media lawyer, I can come in and present my arguments to the court, and I'll argue that the party, whoever it may be, who's moved to close these proceedings, has to present some evidence. And I'm there to support the benefits of the public access and the potential alternatives to closure. A hearing is required. So there's lots of cases where a judge closes proceedings and there was no hearing. A writ of prohibition is filed, and the court will say, well, you didn't have a hearing, you have to have an evidentiary hearing. And the public is allowed in that hearing. So a lot of times, for example, in the Chardon case, the court was, as I recall, saying only the lawyers can be in there for the proceeding. No, the public is allowed to be there and watch that closure hearing. So what do you do as a media lawyer? You come in, you argue the balancing test. An argument that I am almost always making is the cat's already out of the bag. A lot of times people don't want to disclose the identity of the juveniles involved, but a lot of times the names of these juveniles have been already plastered all over the press. So that's one argument, and it's supported by the case law that the cat's already out of the bag. We argue that the publicity might help prevent future acts or alert parents to dangers. It's a check and balance. Public access is a check and balance on the judicial process. In Steubenville, there was this allegation of a cover-up, and we argued that having the public there could prevent that public outcry. It could educate the public. There could be benefits to the accused if it's closed and an accused is later found to be not guilty. People will wonder in the public, was this a cover-up? And we often concede not to photograph the victim. I think if you come in with a reasonable approach and think about things that you would be willing to concede not doing, it helps your case. With respect to access to juvenile records, starting again with the general rule, court records are presumed open to public access. But then there's, of course, a different rule for juvenile records, where it says no public use shall be made of any juvenile court record, including the recording or a transcript of any juvenile court hearing, except as authorized by order of the court or by statute. So that except is important. Oftentimes, judges will say, well, I can't, this rule prevents me from allowing use of any court record, except if I make an order. Well, the judge has to look to that same three-part test. That's what the cases have said. It's access to juvenile court records is the same as access to juvenile court proceedings. If the judge wants to bar access to the records, it must find that there's a reasonable substantial basis that providing those records could harm the child or endanger the fairness of the adjudication, and that danger outweighs the benefits to the public, and that there are no reasonable alternatives. Redaction, personal identifying information, those types of things are alternatives that we always discuss. Special considerations regarding juvenile dockets. The Floyd case, which Ms. Dissel was involved in, discussed that the court has to make the docket available so that the public can know if there are going to be juvenile proceedings closed. And the Floyd case also found that if the hearing is going to be open to the public after doing that three-part test, then the transcript should be available to the public as well. And those issues came up in both, well, it came up in Chardon, when we wanted access to the docket, the motions and the pleadings, and all those types of things. So that's my general overview of the law, and I'll hand it back over to Professor Gillis.
So reactions from Rachel, I know Joe is going to come up here and respond. So Rachel, Judge Gill?
I think one thing that I want to point out is most of what we're talking about today is the times in which we've had to go into court and make arguments over these cases, and that people know we're making arguments, there's motions being filed back and forth, a judge is having to make a decision. What I found, I started covering the juvenile court in Cleveland in 2004, 2005, and when I first started showing up there, in fact, a lot of the juvenile attorneys that were there, I would have to hand them in Ray TR because they had never moved to close a hearing before. And they would just stand up and say to the judge, I don't want the press here. And I would say, well, we got to do something about that. Let's have a hearing. And they didn't even really understand the process because nobody had tried to really come into the court very often before. So I really started to have conversations with a lot of the lawyers that practice in there a lot about their cases, about why they wouldn't want the media there, about what did they not want the public to see about what was going on. And often we could have very good discussions before ever getting to the point of having to have a hearing where they can explain to me their concerns, I can explain to them what I plan to do, and we could come to an agreement that we didn't have to have a hearing. Often if there was a very, very young client, we weren't going to use their name or photograph them anyway. Often if they had a concern about a mental health issue or something like that, or a safety issue, we could talk about it and work through it and get to the point where we didn't have to have a hearing. The other thing I think I should explain is that often media sources in the past would have policies on naming or not naming juveniles. When I started at the Plain Dealer, well, we don't call them policies anymore. We call them guidelines, so we don't have to follow them all the time. But we had a case-by-case decision-making basis. So each time a case would come up involving a juvenile, I would have to call an editor, give them a 2-minute explanation of the case, and they would say, name the kid, don't name the kid. After a while, I grew really uncomfortable with that. I kind of thought that we weren't putting enough thought into how we were doing that, and so one of our editors, Susan Goldberg, said, well, when are we naming kids and when aren't we? So I went through our archives and found out, lo and behold, that we were often naming inner city black kids and almost never naming white kids from the suburbs. And I had a real problem with that. And so we had a long discussion about it. She then changed the policy as that we were not going to name any kids that were first charged in juvenile court unless they were bound over as adults. And our exceptions would be public safety exceptions, such as in the Chardon case, during reporting, if there was someone who had been shooting and could be on the loose or was being sought, we would put a name out there. More recent leadership at the paper has decided that after a case is over, if someone is found guilty, then they feel like it's acceptable to use a name. So for instance, during the entire Steubenville case, the Plain Dealer is probably one of the only media entities out there that did not use the name of the 2 juveniles that were charged.
Judge Gill, any reaction?
Well, listening to Rachel reminds me of my experiences in the courtroom. I've never had Rachel, I don't think, in my courtroom, but I have what I think is a very good relationship with the media. And the media that comes into Franklin County, even from the AP Press, often approaches the whole system and the request much as Rachel has described, which is really respectful, asserting their right and the public's right to the information. But under our local rule, if we have a media request, we have to advise all the attorneys involved in the case for the juvenile as well as the prosecutors so that we can decide whether or not we're going to need to have a closure hearing. And more often than not, what I will do, particularly given the docket in the morning and waiting for the time to have the closure, is I will send them all out to talk with the media and see exactly what media wants to do, who do they want to photograph, has the name already been out. You know, in today's world, the cat's almost always out of the bag before I get there. Whether there's Facebook or Twitter or whatever that it's on, or a youth's own Facebook page, you know, it's so often already out there. So we just sort of work. I don't know whether it's because the Lias case was in our court. We really follow that standard, that it's a rare case, and that there really has to be a show of harm. Much as Rachel said, we look to mental health issues or very young children and try to make agreements as it relates to that. But I've never had a problem really with media not trying to work out an agreement. I was the judge that sat on the Rivka Berry case, and Rivka is now over the age of 18. But by the time, I don't know if you remember that case, that was the Muslim girl that had converted to Christianity and ran away to Florida. Well, if you remember anything about it, by the time it got back to Franklin County, it was a complete media event in and of itself from Florida, nationally and internationally. What was interesting about that case, I thought, was that all new lawyers were on the case once it came up to Franklin County. There may have been, Rivka may have had one left from Florida that started in the beginning, but all of the Franklin County lawyers immediately agreed to a gag order between themselves and agreed that they did not want to have the media involved in that. Now, what also was interesting, that shortly after agreeing to it, both sides decided that they wanted to be the ones that get to talk to the press, and not the other side not to do that. And eventually we did have the press in the courtroom. There really wasn't a request for the press to be in the courtroom early on until after things really kind of heated up. But again, that was an interesting case to weigh, because in my perception, the minor child and her party really wanted the matters in the media and to sort of to argue about this in the press, as opposed to a more usual case that Joe might be defending against, that the youth does not want their name in. So, you know, it's a relationship kind of building thing, and working to make agreements, and I've always found that for the most part it works.
And I would say that the delinquency cases are a lot easier,
Yes.
because usually the press does not hang out in juvenile court for every routine delinquency case. Usually when the press shows up, there's some public reason that they're there. I think the cases that are a lot harder are the custody and the Children and Family Services related cases, where there might be an interest for a good reason, but working through some of the issues in those cases I think can be much more difficult.
I think that's a good point.
I'm going to segue to Joe, who'll tell us does the juvenile want the kid in the court? Yeah, a question.
Just a clarification. I was a reporter involved in Dispatch versus Loudon. That was a kidnap murder with multiple defendants, and that what I was kept out of. Not only was I kept out of the court hearing, I was kept out of the courthouse by a deputy as the public was streaming in. And we got our lawyer right on the phone with a cell phone, try to argue for that, delay the hearing until we can have our attorney Marion Little up from Columbus in 30 minutes for that 3-part hearing that you talked about. But it turned out the court administrator gave the order no press, and the judge, after the fact, told me whom I knew. Said after the fact, he apologized, said, I didn't even know their press was outside the courthouse. Well, this was the initial hearing for one of the suspects, and there were details about the crime given that would have made a story. We got the transcript a month later.
So I'm just going to make a comment. So the question from the audience, because they're taping this, was that sometimes court administrators will exclude the press without the judge even knowing.
Smaller counties.
And especially in smaller counties. Do you want a quick
I think
reaction?
that brings up one good point too that I don't know the answer to, or the resolution, so maybe you guys know. In certain courtrooms, judges have no problem with me getting up and making that three-part argument. In Cuyahoga County, it's not a problem. In most places I've gone. In other places, judges have said, absolutely not. You're not an attorney. You can't make this argument. I've never heard really, we've never been a resolution on it, because usually if we have to get an attorney, we can get one there, get a delay to get one there. But
carry the card in my wallet.
yeah, we have cards in our newsroom that we hand out to reporters that have to cover juvenile things. But I've heard judges have opinions both ways, that lawyers can make that argument, or that reporters can make those arguments, and that they must be a party to the case, and to do that they have to file something and have someone representing them.
I can say for my part that I have had reporters make the argument. I'm not 100% comfortable with it, but I always inquire before they make their argument if they've advised their lawyer that they are there and going to be making basically a pro se argument.
And I would just add that, yeah, I mean, the communication with the courtroom administrator is, in a lot of these cases, key. I mean, you can, especially in the Steubenville case that I handled, you can learn a lot about, you know, how this particular judge wants to handle the issue, how he prefers the media to approach the court. I remember in Jefferson County, there appeared to be 2 or 3 different local rules that were applicable, and the courtroom administrator was helpful in directing us to what the court wanted to focus on. So, yeah, I mean, they can have a lot of power, and having that communication can be key.
I'm going to turn it over to Joe Nye to tell us, what does the juvenile want? Do you want it closed? Do you want it open? What should we think of from the juvenile's perspective?
Thank you. This is a lot more interesting topic to me than telling you definitions in the juvenile rules. So if there are questions about this, I know we're going to segue into that at the end. So I hope this does spur some conversation between us. But I think there is a big difference between what media lawyers, the media themselves, and the juveniles want to see happen in these cases, including the general public. The biggest point that I want to make is that juveniles are different. And I said this earlier, and I'll tell you again, is there's a separate and unique court for children. There's different terminology, and there's different rules, and there's a reason for that. If they were the same, we wouldn't have this separate court system that exists. I'll give you an example. This is Eric Thomas and Devontae Johnson, just recently in the dispatch. These are the kind of individuals that are in juvenile court compared to the people that are in adult court. We realize that there's a difference between them, and you can tell this is probably a pretty different picture than we usually see of juveniles, but I think it illustrates it well. So I put up here, sure, there's a separate system, but we all know that there's not that much of a difference between children and adults. Well, I think that here are some studies that will show you that that's not necessarily true, and what the Supreme Court said. First of all, there's no scientific foundation that children who commit sexual offenses pose a danger of future sexual predation. In fact, one recent study shows that recidivism rate for juveniles as low as 1%. So a lot of times we hear and we see in the media in general is juveniles who commit sex offenses grow up to commit them as adults, or the adults were obviously abused as children. That's not at all what any of the studies show. So studies consistently conclude that sex offenses are committed by individuals that were not known to be juvenile offenders. So publicizing someone who's committed a sex offense as a juvenile doesn't necessarily protect the public, because more likely than not, they are not the ones that are committing future sex offenses. Recent studies on cognitive development and brain function of children have caused the United States Supreme Court to treat children different than adults. I'm going to go through several cases in a second, but Roper versus Simmons, a very famous case, was well covered in the media. U.S. Supreme Court held that juveniles are categorically less culpable than adults when they commit offenses. So one of Kevin's arguments are, we want to let the public know because we want people to be aware of these individuals. Well, they're categorically less culpable than adults, but yet we want to treat them the same in the media. Juveniles wouldn't necessarily want to have that happen. Most recently, in 2012, Mellor versus Alabama, children are constitutionally different from adults. They have diminished culpability and greater prospects for reform. They're less deserving of the most severe punishments. They lack maturity, underdeveloped sense of responsibility. They're more vulnerable to negative influences, outside pressures, and a child's character is not as well formed as an adult's. So specifically in this part is, children are more vulnerable to negative influences and outside pressures. So putting a juvenile in the media, giving the general public information about an indiscretion of a youth, shows that the United States Supreme Court, if you haven't read about this, there is a voluminous amount of amicus briefs about brain development and about juveniles in it. And that's where they came from, this saying, we don't necessarily want to treat children the same as adults. And our courts actually do treat them differently. For example, Roper versus Simmons held the death penalty for children under 18 when they committed the offense is cruel and unusual punishment. And the 3 reasons why are repeated in all these subsequent cases. So I'm only going to tell you once, but due to a lack of maturity and underdeveloped sense of responsibility, youth are more likely to engage in impetuous and ill-considered actions and decisions. Youth are more vulnerable or susceptible to negative influence and outside pressure. And the characters of youth are not as well formed as those of adults. The personality traits are more transitory and less fixed. So again, we have youth that are developing and can have a chance to reform their life, and if you put out in the media, you think that some of these people that are out there, let's say in the TJ Lane case, it ends up that this didn't happen. No, that's not possible, but it ended up it didn't happen. Do you think that anybody will ever forget that name, forget those pictures? They won't, so there's no chance for some of these people. A life sentence without the possibility of parole is cruel and unusual punishment for a youth. That's from 3 years ago. 2 years ago, age is a relevant factor in determining whether or not a suspect is legally considered in police custody to receive Miranda warnings. So that's a huge national case, JDB versus North Carolina. The court specifically held that mental capacity and other generic specific I guess character traits for people couldn't be considered, but the age was so important and so unique that it did need to be considered. So this is what I say, so that may be true, but one of the things I talked to Kevin about, well, the general public doesn't think juveniles should be treated different. They actually want to have this information, don't they? Well, actually, that's not true. When the most recent surveys were done by the Campaign for Youth Justice, 78% of adults want the focus of the juvenile justice system to be on prevention and rehabilitation, not on punishment. 2/3 of adults surveyed want a minimum age for a child to be prosecuted, and 76% of adults believe that youth that commit delinquency offenses are capable of positive growth and change for the better. Now remember, this is just, I'm giving you the juvenile's perspective. If 76% of adults want children to have a chance to change for the better, we want that information out there. That's why juveniles may not want it there. This is a really graphic example that I'm sure you've all seen before, but is the risk more harmful to juveniles if information is manipulated, which is most likely not the case, but are misreported because of misinformation given? I'm sure you've all seen this before. This is the exact same booking photograph of O.J. Simpson that was adulterated by Time magazine, where they darkened his photograph and they put it on the front cover of the magazine. This is the most important part of this to me, and I know I'm going fast, but we do want to get to the end of this, so I promise I would try to move through this. But how could this actually harm a juvenile? That's the biggest question that I've gotten when we prepare for this is, could it really harm a juvenile, and how? Well, there's irreparable harm to a child's reputation. If it's in the media, it's always there. We tell people now, I do a lot of things regarding sexting now, telling people if you text it, you put it on the internet, there's no way to take it off. Same thing goes for the media. You put something about a juvenile on the internet, it's not coming off from the media either. It creates a public stigmatization. Reward a child for giving them publicity. This is from the Plain Dealer, but this is a front page article. It appears to the court that the defendant simply wished to make a name for himself, make a big splash, or be front page news. It's on the front page. So sometimes the reverse is true. Juveniles do want to be on the front page of the news, and we reward them by putting them on the front page of the news. Promotes punishment and shame instead of rehabilitation. Here's amicus curiae from a different case, but legal scholars have theorized that the use of shaming penalties to punish juveniles is not only ineffective, but it leads to further delinquency, will have a negative impact on already troubled juveniles, and may actually contribute to juvenile antisocial behavior by aggravating the reasons the juvenile acted out in the first place. The last two that I put, and obviously this is not a comprehensive list, it's just 6 thoughts to add. Limit future employment and educational opportunities. I think this is a common sense thing, but all that's been done by in a specific article about privacy and publicity about media coverage in juveniles. Employers are less likely to hire juveniles with a criminal or juvenile record. Many juvenile confidentiality advocates argue that juvenile records should be closed for youth to have a second chance at job opportunities. I'm going to give you a quick aside. It's something that I get a lot of phone calls about from either state boards or state educational institutes. Applications used to always say, and this ties into the first thing that I told you about the specific terminology, have you ever been convicted of a crime? We can, in all good faith and under the law, tell juveniles if you have been adjudicated delinquent, you have not been convicted of a crime, and you should never check that box. Well, 2 things have happened. So colleges now say, well, we think that's convicted of a crime, so we're going to kick you out anyways if they're a private institution. And certain boards across the state have changed their paperwork to say, have you ever been adjudicated delinquent for committing an offense or been convicted of a crime? So those things do come in there. I know people previously had said to me, well, people don't know about your juvenile record. That's not the case anymore. It's not how it used to be. People do know about your juvenile record. And then negatively impact family, peer, and community relationships. This is the final thought I'll give you before we go into our next section of this. But this is a really important quote. I know this quote is not a recent quote. It's probably about 45 years old, if I did the math really quick in my head. But I think it's important. The juvenile court stands as a monument to the enlightened conviction that wayward boys may become good men, and that society should make every effort to avoid their being attained as a criminal before growing to full measure of adult responsibility. Its existence, together with the substantive provisions of the Juvenile Code, reflect the considerations of opinion that society that childish pranks and other youthful indiscretions, as well as graver offenses, should seldom, warrant adult sanctions, and that the decided emphasis should be upon the individual corrective treatment. So I think that's the summary that I want you to have as the takeaway from the juvenile's perspective is, if anybody in this room can tell me that they made the same decisions today that they would have as a juvenile, or if they didn't do something as a juvenile that they don't regret, they weren't embarrassed by, I would be surprised. I've never yet seen anybody, I certainly don't put myself in that category. And I think that's the most important thing that I get in talking to juveniles. I don't know that they fully appreciate what they do. The most recent studies by Thomas Grisso and the brain development show us that until into our 20s, we don't really have the ability to fully understand the decision-making ability and the consequences related thereto. And I tell people, and one of the things the United States Supreme Court said is, the easiest thing for all of us is we all fall into one category. Everybody that's listening to this and everybody that was part of the arguments in the Supreme Court was once a child. So everybody falls into that category, and everybody has an individual experience that's not unique because we all were children at one time. So I think that's the biggest takeaway that I guess what I would ask everybody to take from this.
At this point, I'm going to ask for questions, and then we're going to move into discussion of how these play out in specific scenarios people have dealt with. So, question from the audience.
I understand that newsrooms fret all the time about whether to use the name or whether not to use the name, and I think it should be a case-by-case situation done responsibly. But has there ever been a lawsuit against a newsroom for using a name of a juvenile? Or is that name available to anybody who wants to use it based on the situation?
So I'm going to repeat the question while someone thinks who wants to take it. The question is about using the names of juveniles and whether there has been a lawsuit challenging the refusal to release a juvenile's name.
There's a common misperception that there is some law out there that prevents reporters or the media from using a juvenile's name or a juvenile's image. There's no such law. If the media wants access to proceedings or wants to report the identity of a juvenile, they're entitled to do so until the court tells them otherwise. The standard is the three-part standard that I just discussed. There have been times where courts have tried to look for reasonable alternatives, and they have issued orders that say, okay, we're going to allow the media access to this, but the media is not allowed to do X, Y, and Z. I would argue forcefully against any kind of restriction against using the identity of a juvenile. I mean, you'd have to come up with, some reason that the identity of the juvenile and the harm that it could cause the juvenile is outweighed by the interest in the public in the matter, and that there's no reasonable alternative to that. So it has come up, but there is no statute or law that specifically says you can't do it.
Okay, what I'm going to move now, I think, is to a discussion of how these principles play out. First, we're going to discuss the Steubenville High School rape case. And I realize all these cases are very sensitive to different people from different perspectives. So I think we're all going to keep that into consideration as we discuss these cases.
Susan, before we start to talk specifically about that, I just wanted to bring up one point that Joe really made me think about. Most of those things he put up there, I absolutely agree with. I've read all those studies. I've reported on a lot of those studies. But I do need to point out that the public would not know about most of those cases, most of those studies, most of that research if we didn't report on juvenile cases and have access to them. Some of the best evidence as to how juveniles are different and how we need to treat them differently comes out of those cases and those proceedings. That science, and I think there are many, many, many good reporters and good folks in the media that marry those two things together, and I think a lot of those Supreme Court decisions would have never gotten to the point where they got that attention. I think some of the really big studies on that have reversed the trend in incarcerating juveniles, you know, and put fewer juveniles in prison have come out of reporting on those issues and the negative effects of that. So it is really hard, and I think as we go into talking about the Steubenville case, it's a great place to start the discussion with balancing individual harm to juveniles possibly that can be done, or individual concerns with the concerns of the general public, and also the general public knowing about these things so that there can be a conversation that leads oftentimes to positive change.
So I'm going to ask you to lead off and give us the background of the Steubenville High School case, which you were involved in reporting on.
Yeah, I think, you know, we reported on this case. We were probably beyond the local entities, one of the first entities to report on it. And I really try to, in all of these situations, be very honest. Looking back in hindsight now, I can look back at what we wrote, and I believe that our intent to report on this case in which 2 high school football players were accused of raping a young woman, our intent was to write a story that let people know that this happens all over, at parties and on weekends. These types of accusations come out a lot, and oftentimes they don't get reported. Oftentimes they involve athletes, sometimes they don't involve athletes. And I think what then happened with the case after that, it's hard to look at some of it. It kind of got out of control, and I'm the first to admit that. I did not expect social media to do what it did, hackers and folks getting involved. But what we wanted to report on was the basis of the allegations here. You know, that several high school football players, you know, went out. They were at parties on a weekend with a young woman. The young woman was intoxicated, and they took advantage of her and raped her. That was where we started. And so I think after that, so much other stuff happened. We could probably all talk about it for a while.
So what I want to use the case to do is to ask for best practices. So Judge Gill, if you've got a case like this in front of you, what would your first instincts be? What would you do when Joe and Kevin start showing up?
Well, the first thing that I would probably do is hold a hearing to take a look at what was going to be covered, what evidence was going to be presented, and I forget what those hearings are called. It's not the closure; it's the pre-closure hearing.
You mean I would
like
call
in the Elias case.
I would call it a closure hearing, but I'm not.
Well, in any event, I would review it at bench, and I would have the press there as required by law, both sides there, and we would take a look at what it was to decide whether or not to have people, to have actually the closure hearing open to the public and open to the media. And then take that step, the next step, assuming that then we decided to have the closure hearing and go from there. But the focus for me is going to be on the balancing of all of the interests in the case. I think that it is important to think about the whole public policy of the situation, but on a case-by-case basis, take a look at that situation. There's always, and to be frank and honest, that feeling that you want to keep control as much as possible. And I think that sometimes that is seen by the media as trying to interfere with you having open access, because there's that feeling of lack of control when the cameras come in and all of that kind of thing. But it really would just be a balancing for me, just as I'm sure that Judge Lips did.
So, Rachel, if you're at this pre-closure hearing, what are you going to do?
I don't think that I've ever really had I think there's only very, slim instances in which those hearings are held. It's a very narrowly tailored thing. So I haven't really, I think maybe only one time that there's been that conversation that wasn't the closure hearing before the closure hearing. And I think I believe legally it's very limited. So I don't have a lot of experience with that. But I think normally that conversation is between reporters and attorneys in a hallway or in a room. What are your concerns? What are my concerns? What are you looking to report on here? What kind of access do you want? I mean, usually that conversation happens, but that doesn't usually happen in a courtroom from my perspective.
So, Joe, I'm interested in how you're making the decision whether to vigorously oppose access, moderately oppose. Do you talk to your client? How do you make this
Well, I
decision?
think it's their decision. I think just as Kevin's client's telling him what to do, we have the same requirement to talk to our client.
You have a juvenile.
Yeah, I have a juvenile. They still get to make the decisions. I think one of the things to answer the question you asked Judge Gill, though, also, and you say, what's one of the first things that you do? The first thing that I would do in any of the cases that we're going to talk about is say, get rid of your Facebook account. Quit sending pictures to your friends. I mean, I will give Kevin this. When I go back to talk to a juvenile and they would say, I don't want this to be on TV, I'd say, did you send it to everybody on Facebook? And they'd say, yeah. And I wouldn't say this in the courtroom, obviously. I'd say, well, what argument would you like me to make that you don't want everyone to know when you've already told everyone? So that goes into the decision with the juvenile is what have they done to disclose it or to keep it private? What harm they think might be to them, and then use the things that I talked about earlier to try to argue that. Now, there are occasions where I talk about TJ Lane, when we're not there yet, but where juveniles will say, I want to be on TV. And one of the problems that we have as defense attorneys, I've never done this, but a lot of defense attorneys benefit specifically from their case being in the media. So when Rachel says, well, they talk to the attorneys first, it's really tough because there's plenty of attorneys I talk to that would want their case to be in the media regardless of what their client says because they want the press. They want to be in that picture sitting next to them. They want everybody to see their name on the front page of the newspaper.
So, Kevin, I think Judge Gill's about to hold a closure hearing. What position do you take? Do you always take, we get in, let us in, the standards met? What position is the media going to take?
Well, I mean, if we're talking about this in the context of Steubenville, every case is different. And in Steubenville, I mean, one of the important best practices is talk to your client ahead of time to understand what are they going to go to the mat on and what are things that they might be willing to concede. On Steubenville, we were clearly willing to concede that we weren't going to film or photograph the victim. And so that was one thing we came in with. The thing that, I mean, and like Rachel, when Joe was going through his presentation, there wasn't really much there that I disagree with. I mean, juveniles are treated differently than adults. That's absolutely correct. But you have to look at the facts of each individual case and present your argument why this case is unique and why there's a specific public interest that outweighs any interest or concern that the juvenile might be harmed. And in Steubenville, I thought it was an easy case to make because we had this huge public outcry that football players were being treated differently. There was this cover-up, that there wasn't going to be a fair trial. My view was, and what I argued to the court was, if you cover this case up, people are still going to be talking about this, and they're not going to be getting it accurately. Here's an opportunity to get it accurate. You can get accurate reporting on this trial. And what happens, Your Honor, if these two boys are found not guilty? You know, consider what the public outcry will be then. People will say that this was a cover-up, and this is your opportunity to have this open and for everyone to see that these juveniles and the victim and everyone is treated fairly. So that was a case. Of course, there are always concerns for the juveniles, but that was a case where I thought it was a very strong case to make that the public interest outweighed those concerns.
I would have to say that the information that came out after the court proceedings began and were open was far more accurate than the information that came out prior to that.
And the interesting thing was, I mean, you asked Joe what cases would would you want, would the juvenile want to file a closure motion? In that case, in Steubenville, there was a motion filed by the juvenile. The victim filed a motion supporting that. And then we went in, I lawyered up and prepared the brief and went in to argue it. And prior to it, I was getting calls from the juveniles council talking about, is there anything we can agree to here? I won't talk about what our discussions were, but that happens. Maybe sometimes there's discussions. And then when we got in, the juvenile's attorney withdrew it because I think at the end of the day, they were hearing the logic that this might be better for my client to have this open. And I'm sitting there thinking, well, there's no motion before the court. There was the victim who supported that motion, and I never heard at that hearing any kind of oral motion for closure, and so I argue there wasn't any motion before the court, but the judge sort of ignored that argument. And in his decision, the judge said that there was an oral motion from the state to close the proceedings. And the state did stand up and argue that they should be closed. So arguably it was closed. But it was an interesting situation where I think the juvenile at the end of the day changed his mind and decided, hey, this is better for me to be open.
And I think that was really odd because I'd never been in a case where the prosecutor, almost never in the cases that I've covered have the prosecutors, they usually just kind of stay neutral
Right.
for the most part. And I immediately, when we saw the motion filed from the juvenile victim, I started to try to search through law saying, does this person have standing to file or to be part of one of these motions? And I wasn't sure. And in the end, I guess we didn't have to end up arguing that. But I had never had that experience because, for the most part, I can't think of any media entity that would name a juvenile victim. And and so we had never encountered that before.
And in Franklin County, there's actually a local rule that says that you can't, I believe.
Yeah, Juvenile Rule 9.
And we knew that witnesses and victims would have the choice as well as to whether they were going to be shown on camera.
Any other best practice learning from Steubenville, things that went wrong that could have been prevented, things that lawyers did badly, judges did badly? Or should we move on?
I think, the Jefferson County Juvenile Court was kind of, I kind of felt bad for them at some point. They were really snowed by so many requests, and they felt like they were trying to do their best job to accommodate the media, but it was really hard for them. And I think they were also operating under a situation where they had a visiting judge who wasn't there, and then people making requests all the time. And I know that, we had made a request very early on for access to the docket so we could see some of these motions that were being filed, and we're just not getting very good response. And so we ended up having to litigate that a little bit. And we tried to avoid having to litigate it, at least in some part, by posting some stories online about what was kind of being denied to us, which was access to the docket, and to at least know what motions were being filed by sending the court messages and then reporting that they had denied it and then citing the case law. In one instance that worked, but then in the end we did have to follow up on the case afterwards and go down and have a hearing on getting many more of the motions that we didn't have access to during the hearing or during the trial.
I want to add one quick best practice thing that Kevin brought up that I think is the most important. I've never had a case, nor do I know of anyone in my office that's had a case, where the media has, through their attorney, just showed up or, like Rachel said, never talked to us to try to work things out. And I think, talking about best practices, it may sound like, and there may be a perception that the media is just surprising everyone and trying to get all this information. That's never been my experience. It's been that they are willing to consider what you have to say and why. And I think what Kevin said about trying to call first to try to see what do we really disagree about, I think is probably the best practice. And even if it's not through an attorney, if the media would just call and say, this is what we'd like to do and why are you opposed to it, which happens a lot, I think that's the best thing that can happen.
Questions from the audience about the Steubenville case? I'm going to move then to the, Kevin, you didn't have a picture. Okay.
I think it was the first picture of the three.
Okay. The next one we were going to look at is the Chardon High School shooting. So anyone want to tell me why they think the dynamics were different? Should we start with Rachel again?
I don't know that they were all that different. It was just a lot more media entities trying to pack into one very, very tiny courtroom in Geauga County. I think, too, that the fact that Chardon is so small and that everybody knows everybody there. I think anytime, you're in a place that's very small and tight-knit, the dynamics do kind of feel a little bit different. I don't know that I can legally cite how they're different, but they do feel a little bit different. When you walk into the courthouse on a case like this, every person that works there personally knew somebody affected by this. And so it just kind of does shift the dynamics and the gravity of what was going on. But our arguments were the same arguments that we would always make, and I think in this case we felt on very solid ground making the arguments.
I wonder if you felt a different in the dynamic just along the lines of what Kevin talked about, that Steubenville that sort of idolizes their football team and has them up as heroes, and your, I think, very compelling argument that to close the hearing in the shroud of silence would have been more dangerous overall to the process, as opposed to a very small, everyone's similar community, and something along the lines with these mental health issues.
I mean, the crimes were also very different in the impact too that they had. I think that the Steubenville crime has really had a huge ripple effect, whereas the Chardon crime had an immediate, very traumatic impact, and that, I think, was why it kind of felt different, but also made it even more important to be so cautious and so accurate about what was getting out, especially in those very first few hearings.
Well, I think there's a specific difference between the two also in the accused. In the first one, you have people who, as the judge said, are idolized in the community, are members of, I'm sure if you've read all this stuff, their families are big members of the community, and they're people that were already well known in the community. You don't have that in Chardon. You have somebody who was basically not known, who now wants to be known. In the first one, you have people who are known who don't want to be known. So I think they're kind of... Yeah, for that reason, yeah. They want to be in the media for athletics, not for offenses they've committed, and you have somebody else who's not well known for anything and then wants to be known for this. So I think the dynamic is completely different when you have the individuals that are involved in it and they want to be in the media.
So how strongly would you counsel a juvenile to stay out of the media? Is that going to be your predominant message, or are you going to be pros and cons?
Well, I think you have to weigh it based on the circumstances. I definitely would say that I would start from the perspective that I would want to know why they would want to. I think Kevin makes a good argument about, listen, if you're wrongfully accused and everyone thinks you've already done it and it's on social media, maybe you want it to be open so you can get the truth out there. Now, it didn't really work out the same way because a lot more information came out during the hearing. But I think you balance those two things and you give them the information, because I don't think juveniles know about brain development studies and some of those things, but explain to them the long-term repercussions for it and have them weigh it out and help them. I know that, I think it was Ian Friedman that represented TJ Lane. If you read at the sentencing hearing, the statements for him, he made statements saying, like, the defense is very sorry for the community, nothing from TJ Lane, because that's not what his thoughts were. So there is part of it where you have to do what your client wants and then have some authority to be able to say, can I have this leeway to argue about this issue? So,
Kevin, media lessons from Chardon?
Yeah, I mean, there were some differences that I remember, some significant ones. One of them was in Chardon, when we walked in, there was already an order that the judge had issued that the media was not to photograph not only the victims' faces, but the faces of the family members of the victims. There was a general order that prohibited the media from photographing TJ Lane in shackles. We had some things that we weren't allowed to do, and we were also seeking records. As representative of CNN, we were not only seeking juvenile records and some paternity records, but we were also seeking records, victims' juvenile records, and the abuse and neglect and dependency records of TJ Lane. Now that was a much harder case to make, and we won on probably the things that you would think we would win on. We won on getting TJ Lane's delinquency records, and we won on getting the paternity records of TJ Lane. We did not get the abuse, neglect, and dependency records of TJ Lane. And we had, another difference was, before the proceeding started in Chardon, we went into the court's chambers and had a discussion about, is there any agreement that could be reached? And one of the things you can take away as a best practice is on these abuse, neglect, and dependency records, I had no idea what I was arguing we should get or shouldn't get because we didn't know what was in them. The case law, at least with respect to dockets and motions and those types of things, is that we have a due process right to at least get an idea of what it is that we're arguing in favor of, and that's why we should get a docket. And we argued in that back room that I understand the concerns about the abuse, neglect, and dependency records, but you guys need to at least give us an inventory of what's in there so I can argue if there's anything in there that is in the interest of the public. And so we did do that, and they summarized for us what was in those records, and they explained to me that those records were so muddled with family history unrelated to TJ Lane that those records, the court was never going to produce them. And so we lost on that issue as well. There was more of an evidentiary hearing in Chardon. In Steubenville, we got up and made arguments, but there were actual witnesses. So there were a lot of differences. The interests of the public were different. But in the end, the media did get access in both cases. I remember having trouble dealing with and this idea that we couldn't film the families' faces ended up going away. I remember struggling to tell the client how you're going to do that because they had no idea who the families were.
Questions from the audience about the Chardon case? Yep.
I have just a general question for the judge. If I could.
Sure, I'm going to have to repeat it, but
Basically, before the session ends, I'd like to know, Judge, how you feel as a trier of fact and as a juvenile court judge in terms of media access. Are you generally in favor of media access? Have you had to close? How often have you closed hearings to the media? But is your, like the Constitution says, all courts are presumed open, even though their juvenile court is a different breed of cat.
so
How do you feel generally about open, close, and have you done it often?
So the question to Judge Gill was, what's her feeling about whether juvenile court should be open and closed, and what's your general practice been?
I mean, as a general principle, I believe that they should be open, and they're presumed to be open, and I think it has to be a case-by-case basis. I would say in the 7 years I've been on the bench, I've maybe had 10 closure hearings, and I've never ended up closing a case. What I have on 2 of the cases, they made an agreement with all parties not to photograph the juvenile, but both of those young men's name was already in the press, had already been in the press by the time it was before me, so they used the name. But again, when I'm starting with that presumption, I think the burden is on the person that wants it closed, and I think it has to be case by case. But I've always had a good experience with working with the media and defense attorneys, and my experience is, as I think was Rachel said, usually the prosecutors stay back as neutral.
Other questions? I wanted to make sure we had time for questions. Let's briefly just take a look at the...
Question.
Oh, I'm sorry.
Does anybody's analysis change when there's a bind over and it goes to the general division? I mean, does that change anybody's on how you report it or how you advocate for your client in regard to media issues?
So the question from the audience is whether the reporters, lawyers, judges, media's approach changes if the juvenile is bound over.
I think if it's in the general division, it's an adult court, and we treat it like we treat every other adult court case.
So you treat them like an adult?
Correct, yeah.
I would say that the difference is where it's at in the process and whether it's probably weighs into the judge's opinion, I'd imagine, whether it's a mandatory or a discretionary bind over. But certainly if it's still in the juvenile court portion of it, there's a chance that the case isn't going to be bound over. I mean, I've won a murder mandatory binder before the court didn't believe that the prosecution presented probable cause. And so you don't know who that person is, and I don't know that there's any reason for the general public to know if you can't even reach such a lowered threshold of probable cause, which is nowhere near reasonable doubt. But if it's at the point where they've already been bound over and it's going to adult court, I would agree that I don't think there's really any argument at that point.
Or there could be the interim time when probable cause has been found and then there's a determination of a discretionary bind over, which is the second hearing on it. And again, from my perspective, I would take it on a case-by-case basis, considering the age of the child, the public interest as it relates to the actions that were taken, and you know, you can only do it on a case-by-case basis in my mind.
Real quick, I want to also add, with the discretionary bind over, I don't know what experience everybody has with the two parts of it, but the probable cause portion of it is the actual criminal portion of it, of presenting the evidence. In the amenability hearing is about mental health records of the juvenile, psychological evaluations of the juvenile, their family history. So I think courts take a different opinion, and as would I in representing the juvenile, as to which one of those two things. I think the facts of the offense are a lot of times already out there, but the mental health of the juvenile and their family and their involvement with children's services and mental health and substance abuse of their family, I think would be a little different, and that's what Kevin said. His experience wasn't trying to get those records for TJ as well.
Sure, I think we've had some experiences with that in Cuyahoga County Juvenile Court, and we've had to craft some very interesting agreements. I know that there had been some arguments during amenability hearings that that public access did not extend to some of the medical and mental health records and some of the testimony that would be there. So I remember we had one case where I knew the defense attorney pretty well, and I said, we will not report on that stuff, but don't make us leave the room. We really need to, we need to have the context in order to report. And we agreed on some very specific things, mental health based, that we weren't going to just put into the paper, but we would generally talk about how a lot of the testimony was based on this type of mental health issue. But we didn't specify it because a lot of it had to do with sexual abuse and other things like that we didn't feel was going to be fair or appropriate to really roll out there. And most of it actually probably would never have gotten into a newspaper anyway. So we were able to craft something that they felt comfortable with and that we felt comfortable with.
Just as an interesting side note, in all the bindovers I've done, I would say that 90% of them have an abuse, neglect, dependency filing earlier on in their childhood. So it's kind of an interesting perspective that's going to be in almost every case.
Yeah, I would say with each fact you have in a case that makes the juvenile case more analogous to an adult criminal proceeding, the better my argument is that media should have access. So every case is different. If you're in that interim step where it's being determined whether or not it's going to be tried in a common pleas court, we're probably in a case where I have some better arguments.
Can I actually ask Kevin a question?
You have 1 minute to ask,
It's a very
and you
short
have
one.
30 seconds to answer.
Do you think in advising your clients, though, kind of something you just said, that the more serious the offense, or the more, I don't want to use the phrase like gruesome the offense, or more of those things that help you in advising your client? If it's a rape versus a murder, if it's a string of robberies versus a mass homicide, those things make a big difference to you?
I think what makes a big difference is not necessarily whether it's a rape versus a murder versus something else, but is it something that my client has a strong interest in, and as a result of that, is there a strong public interest in it? And so if I'm asking for something, as we were in the Chardon case that relates to the victims, I'm going to be advising the client that we're going to struggle with that request a lot more than we're going to struggle with the defendant's records or the defendant's
I think you're going to have public interest in many kind of cases. I mean, we did a closure hearing on a case that involved an obese child being removed from his mother, and
Right.
we made the same types of arguments we would have made in a delinquency case about public interest.
So at that point, I'm not going to ask you to join me in thanking the panelists. This session is ended. if you'd like to ask the panelists an individual question, I'm sure they'd be willing to entertain them, maybe even answer them. Thank you.